The information and services contained in this program are intended for educational and entertainment purposes only and are not intended as investment advice. Producers of this content are not responsible for the accuracy or validity of any information contained herein. Please consult your financial advisor prior to any investment decisions.
So hi, Rotorless, nice to see you all, and we'll jump right in.
Hi, how are you? I'm Demian Drabyk. I'm founder of Think and Dev, a blockchain development company. And I was on the space the last 3 years and a half, almost 4.
Hi, everyone. I'm Jalphy Laurent, the account executive at MyDAO, where we believe that DAOs are the future of human organization. We've spoken to hundreds of DAOs over the last 6 to 7 months and found patterns of concern through these DAOs, and we believe that our jurisdiction and our service helps address most of these concerns pretty thoroughly. Thank you.
Hi everyone, my name is JoAnn Holmes. I am an attorney with Holmes at Law, and I am an intellectual property and digital assets lawyer. I help clients figure out the ever-changing legal and regulatory landscape of Web3 with NFTs, DAOs, and the metaverse.
All right, so why don't we kick it off? I'm going to ask, I guess, first Demian, and then it's Jonathan, right? Okay, sorry, Jalphy. I apologize. What type of risks keep you up at night, or do you think about when you think about DAOs?
Well, I'm a builder, so when I have to think about the risk of a DAO, for me, the higher risk is the lack of regulation. So everyone is working on gray, and anyone is knowing what have to do. So the troubles on the future are really high, and you have to think about how you mitigate the risks in the future, because you don't know how to do it right now, and everyone is doing it. So you have to think on that from my side.
Yeah, I would echo Damian's sentiments. I feel like because there's a lack of regulation, we live in this like nebulous cloud of what Big Brother wants to do, and we've seen regulators adopt more of a regulation by enforcement perspective. So that's very difficult for DAOs that are actively trying to change the world and do things in new ways. That keeps them up at night, which also, because of what we do, keeps us up at night.
I would add to that, when I'm advising clients, it's definitely challenging to not have clarity, and it's really fun when the SEC and the CFTC are openly disagreeing with one another about who has jurisdiction over things like tokens and whether they're governance tokens or security tokens. But another thing that I think about as an attorney is just the traditional areas of law, simple issues like corporate law. Do you have some kind of company wrapper that protects the founders and members of a DAO from liability? Have you thought about whether the people who are members and contributors are actually employees? And we have a 50-state scheme for figuring out whether someone is an employee or not. And then, of course, taxes as well. So if you are generating a profit in a DAO, or if you are paying people for their contributions and they are in fact employees, then you might owe some element of taxes in relation to that income and in paying into unemployment treasuries and so forth. So there are a number of issues that impact traditional companies that could also impact DAOs, not to mention the fact that DAOs could include members from all over the world. So it's not just US law, it's law from other countries as well, impacting how those organizations can be run.
Thanks a lot. So, how do you manage that? So, first of all, do you have any suggestions, or for any of these risks? So you see that it's gray. We've heard you have some choices there, which could be to wrap this or wrap that, or to follow some pattern in some place. Is there any other sort of novel solutions out there, or are people just kind of paddling along in gray water, in gray skies?
I think that anything is solving right now, but there is a few ways to do it. There is a few companies mounting the company on Cayman Island, on BB Island, or also Gibraltar or Switzerland, that they have more flexible laws. and they have more regulatory than here in the States. And my recommendation for my side is not financial advice, is try to not own your company in the States, because you will never know what is coming in the future, and when the regulation will come in the future, will come retroactive with all the history for all your company.
Yeah, I would advise, or I wouldn't say advise, but I would suggest that DAOs look into possibly registering in the Marshall Islands. And please forgive me for shilling real quickly, but I feel like, as JoAnn said, like we have the best legal wrapper in the world. That's my personal opinion. I might be a bit biased. For a good home for DAOs, with what you receive as far as limited liability protection, corporate personhood, and the ability to protect your contributors and your voters without necessarily giving up your decentralization aspect, and not having, so you can have a organization that doesn't have a board of directors or officers incurring special liability or special powers. And I think that's a little bit more aligned to the decentralization in a DAO.
I'm going to ask a question of the audience. So how many folks out in the audience are members of a DAO? Okay. And of those of you who raised your hand, how many of you feel like your DAO is decentralized? Okay. So the reason I ask that question is because when you're thinking about how to be in compliance with law, one of the challenging issues that we're all trying to figure out is what law, right? Is it the law of any given state? Is it the law of a given country? Is it the law of several countries? And if you're not sure around the fundamentals of, are we decentralized, then that's a tough question to answer. If you are truly decentralized, if you are a Uniswap or a protocol that is effectively run by members and contributors around the world, and it is in fact smart contract based, then you're going to be in a better position to say no one given country can say that they have ultimate authority over this protocol. But the challenge in a lot of spaces is you can't start an organization and be immediately decentralized. You've got to have a core nucleus of founders and people who believe in the mission, who are going to drive it forward. So that's one of the real issues in trying to figure out, if a client says, what law, Joe, do I need to comply with? We need to start out with asking questions around, what are you trying to achieve? Who's participating? What are they doing? And what's the plan for getting to decentralization? Because it's not realistic to start off like that. And I'd love to hear how others on the panel are dealing with that issue of getting decentralized.
So I have an interesting concept on this, which is that everything starts out with one. So I decide that I want to start a Frisbee league in my hometown. And I go down to the public park and I claim the picnic table. And I say that I'm starting a Frisbee league. And then, I don't know, a year later, there's 10 people in that Frisbee league. And that doesn't mean that it's centralized and that it's a business that I'm controlling. Everything starts with one. I think the gray line is nobody's certain exactly about how long you can be like that before you can claim, because you can't start out with like 10,000 people, right? It has to start somewhere. And that I like to use a lot of these very simple analogies. Often sports ones are really helpful, right? Sports leagues, they're very, very helpful when you think about DAOs, when you think about people, contributors. If you think about even big ones that are worth billions of dollars, many of them are actually unincorporated associations, right? And they have IP. They've been through every challenge known to man, from conduct risk to you name it, and they're still there. They're still going strong. They're still generating revenue. And sometimes we just have to look to some other examples. The most popular form of organization in the United States, in Canada, where I'm from, and probably around the world, is actually the unincorporated association. So that's a starting point. There are vulnerabilities in that, right? You are vulnerable depending upon what activity you're doing, right? And so it's going to be peculiar in every situation. But that there is definitely, just going to this bit about everything has to start somewhere. There's a genesis, and just because there's 2 or 3 people doesn't mean that it's a company, right? And it doesn't mean that because everything has a start somewhere. And that's my unique view, not legal advice.
None of this is legal advice. We're just friends chatting.
So since we have JoAnn here, and JoAnn is an expert on intellectual property, why don't we just take the opportunity to ask JoAnn a few questions about, what type of things should be on the radar if I'm creating tokens or I'm in a DAO from the intellectual property standpoint.
So there are different types of IP that will impact a DAO. First of all, you have a name for your DAO, so that's a trademark. And you could actually adopt a name for your DAO that someone else has legal rights in, and you could immediately be infringing a trademark. The creative assets that you might design in a DAO could be protected under copyright. Let's say that you issue NFTs and there's an element of digital art in those NFTs. Then you've got an asset that's protected under copyright. If you're inventing things, that might be protectable under patent. So there are different elements of intellectual property, and there's no one, while Web3 is natively global and exists everywhere all at once, that's not how intellectual property is protected. So really thinking about the fundamental or first principle that I would talk to a client about is, what do you want to achieve? What's the reason you're coming together? Are you coming together for a financial function? Are you coming together because you want to sell a product or a service? If you do, for example, want to sell a product or service, again, you've got a brand name that you want to think about. And one of the challenges when you go to try to protect that as an asset of the business is, when you go to the US Trademark Office, here in the United States, we now have, for example, Wyoming, where there's the Wyoming DAO. We have Tennessee, where they don't really call it a DAO, it's a decentralized organization, but not necessarily autonomous. So we're starting to develop some structures that are recognized by our governmental agencies, but that is still very much evolving. We have this 50-state system of laboratories where different states are experimenting, but the trademark office, the patent office, the copyright office have not quite gotten there yet. So they're still going to want to understand who's asking to own this asset. And being formed as, let's say, a Wyoming DAO will be an organization that the trademark office or the patent office understands, versus me and my 5 best friends started a DAO is not necessarily something that those agencies are going to understand. So even going back to first principles of Web3, you will be creating IP, and figuring out how you want to use it to raise money in the treasury, for example, through licensing it, is going to be one of those important questions to ask around what are we creating and how do we as a membership want to use it.
Thank you. Any thoughts about, since you mentioned treasury, so if we stop for a moment and we think about DAOs as a DAO is just an organization that controls a wallet of some type. If we use that framework, are there any type, somebody has to turn the keys on that wallet. It's one of my favorite topics. So what type of jeopardy or vulnerabilities do people have if they are key holders as opposed to a voter? Is there any distinction? Any
I
ideas?
defer to the lawyer, please.
Do you want to say anything? Okay, so are folks aware that the Commodity Futures Trading Commission, maybe a month or 2 months ago, by chatbot notified the members of Uki DAO that they were in violation of federal regulation? Can you imagine being notified by the federal government by chatbot that you may or may not have even seen that the government considers you to be in violation? And one of the things that the government looked at is who voted in a DAO. We really didn't expect that merely voting and participating in governance of a DAO was going to put you in legal jeopardy. But one of the things we've got to think about is here in the United States, and this is one of the reasons why you want to think about having a company wrapper, you will default to a general partnership. So again, in the example, if you and your 5 best friends go start an organization and you're going to sell something together and you're not an LLC or you're not a corporation, everybody is responsible for the taxes and the risks and liabilities of that organization. And that's the same case with DAOs. If you go become a member of a DAO and someone does something illegal, or someone violates law and there's a penalty, everybody is on the hook for that. That means your personal bank account, the home that your family lives in. And it's not even just an issue of governmental agencies, it's also the issue that there are lawyers who make their living finding these gray spaces in the law and suing people. That's also happening with DAOs right now here in the United States. So just being informed around how you are working together and what your risks are, and to the point of treasuries and multi-sigs. You know, one of the things that I get asked about is things like trusts and estates. What if one of the people on the multi-sig dies? And we need them to be able to move forward. Or what if nobody else knows the private keys? What are the safety measures that we can put in place? So I want to be respectful of others on the panel.
Yeah, so that's a great point about the continuity of the multi-sig. So I'm going to turn to a technical person. Do you have any thoughts on a technology like dead man switch, anything like that?
For the treasury, for my side, I think that all the DAOs have to evolve, and the most people that love DAOs maybe will be hearing me about this, but we have to make a hierarchy of voting, and no one can be voting anything. For example, I'm a developer, and I want to all the developers for the DAO vote for the next solution. I'm not an attorney, but I want to all the attorneys for the DAO that really knows about the subject will be voting about that. And the people that knows about treasury has to be who manage the treasury and who be voting about that.
Great.
Yeah, I have a question for the
Go ahead.
attorneys on the panel. I'm glad you brought up the point about UkiDAO and the CFTC specifying that it was voting members who are incurring liability, and I feel like it's really concerning because that incentivizes speculation as opposed to participation in a DAO. How would a legal wrapper help protect the voting members of a DAO?
So what a legal wrapper does, and I understand that we're all trying to support innovation, and we don't want to stifle that by inserting traditional law where it's not necessary. But one of the core things that I'm always concerned about with my clients is, how do I protect your personal assets? So if you do have an LLC or a corporation set up, and it's not enough to just have it set up, you also need to do things like, let's say you have a treasury on a blockchain. That needs to be separate from the digital wallet of any given member, founder, contributor to the DAO. That needs to be the wallet of the DAO and not of any individual, because you're creating tax risks for yourself if you're treating it as a personal wallet. If you think about any kind of company, it's not enough to say, I set up an LLC or I set up a corporation. You need to do the things that respect separate finances. You need to, and this gets into a question of, how much voting should there be around the structure? With a corporation, you're going to have bylaws. With an LLC, you're going to have an operating agreement. To the point that someone made on an earlier panel, people don't want to vote about everything. So how do you come to consensus on the ways that you protect the membership unless people understand, which frankly requires some legal guidance? But setting up that wrapper will create the LLC or the corporation as a separate person under US law than the people running and participating in the organization.
Great question. How much time we got? Oh, we have a question right there.
I got the mic on that. Hang on. You beat me.
Joe, you had mentioned I heard you mention about multiple owners for intellectual property and how that can be problematic, particularly with licensing of that intellectual property. Could you talk about that a little bit?
Sure. So I manage intellectual property in 140 countries, and so licensing and monetizing IP is the thing that I love to do. The challenge when you have multiple owners of IP is, who's really responsible for making sure that you have goodwill? Someone might think it's great to go license that IP for child pornography, and someone else might say, we don't want anything like that associated with our brand name, for example. So having someone who can make a decision, and so this is where, for example, with DAOs, you might have sub-pods or guilds where someone who has, or a group of people who have subject matter expertise can come together and say, this is the way a license should work, so we can protect our IP, so we can make sure that we're being paid for it, so that we can make sure we're not giving away more rights than are fair or reasonable for us to do, so we can make sure we're going through the process at the U.S. Patent and Trademark Office or the Copyright Office or all of those offices globally somewhere else, so that someone who's invested in making sure that that piece of the DAO's assets are protected. Whereas if that's not happening and several people are contributing and they're not assigning those rights to the DAO, then they might go out and have very disparate understandings that conflict with one another about how that IP should be used.
Oh, look at this. Floodgates are open.
So when you were talking about having a separate treasury with the contributors, does a multi-sig on a Gnosis safe count with that? Because under my Gnosis safe for my yoga DAO, I have voting structure and snapshot linked in with that, but we still have the multi-sig wallet. But then I'm also using NFTs to bypass the whole SEC thing. So when people are actually buying
we're not
into the
bypassing
DAOs,
anything
we're not
for
bypassing,
SEC purposes.
Okay, but yes, not bypassing, but navigating. Sorry. Strategizing, yes. So navigating, so people are purchasing the NFTs to gain DAO tokens rather than purchasing tokens, but then using the multi-sig still as the treasury for the DAO and the voting structure. Should I be separating that?
So this is not legal advice, but if you were my client and we were thinking this through together, I would start out by saying, let's think about setting up an LLC. And part of the reason you would want that is because you might have certain off-chain things that you need fiat currency for, and you need that LLC to be able to walk into a bank and say, I need a bank account, right? So we would start off with that, and then we would think about what is the governance of the DAO, like what does that permit in terms of tokens and whether they're going to be security tokens versus utility tokens. Here in the United States, we have some very disturbing recent precedent where a federal district court decided that tokens that were intended to be utility tokens are security tokens because some people bought them for speculative purposes rather than for governance purposes. But we don't have very clear guidance from either the SEC or the CFTC as we speak right now. So you might, for example, one of the very real risks that I get concerned about is you might design a token for utility purposes. Someone goes and starts trading it, creates a liquidity pool and starts trading it on a DEX, and suddenly it starts to look like a security token. And you have not registered with the SEC, and you have not done the compliance and expensive compliance things that would be necessary. This is all the more reason why you want that company wrapper. We also have a recent example where, and I was joking, but the CFTC over the last couple of months issued a $250,000 fine to two founders who were doing derivative trading on the blockchain, again associated with UkiDAO. And these very bright gentlemen went out and publicly said they were going to move their either corporation or LLC to a DAO so that they wouldn't be in the guise of the regulators, so the regulators could not get at them. Can I just encourage everybody, please do not publicly on the internet go out and say, I'm doing this so the government can't touch me because I know it would be illegal otherwise. Please don't talk about those things on the internet. Please reach out to your friendly neighborhood attorney and have a conversation about what kinds of things you should be saying publicly. So that's some contextualization. We've all got to be really careful with tokens because the SEC has taken a position that they want to treat a lot of tokens as securities, and it's expensive to be in compliance with securities regulation, especially if you're just trying to govern a DAO, and particularly if your DAO doesn't have a financial function. So you might not even have the money to try to go and be in compliance.
This is super interesting. Everybody's really interested in these pitfalls and avoiding risk. We have about another 7 minutes or so happy to keep fielding questions, and just raise your hand if you have a question. I'll try to get over to you.
Hi, so this is a question for JoAnn. So how would you treat a DAO where all the members are foreigners, but they're operating within the US? Meaning, if you were to be sued, the US doesn't have subpoena power overseas. I mean, they could tell them to present themselves to court, but there's no way to force them into court if they're a foreign citizen. Say you have 5 Canadians operating with the DAO in the US. So what approach, how would that pan out for legal.
How is the DAO operating in the U.S. then? If all of the people participating are outside of the U.S., are you offering products or services to U.S. citizens? Yeah. So the U.S. is not unlike the EU in that our laws and regulations are structured to have long-arm impact. If you think about the EU data privacy law that has been in place for some time, that's intended to protect EU citizens no matter where they are in the world. It's similar with a number of U.S. regulations from a securities perspective. Another thing that the U.S. government cares very much about is anti-money laundering and anti-terrorism efforts. And so when you start to offer products and services into the United States and U.S. citizens could potentially be at risk associated with that, then the U.S. government is going to deem you within their jurisdiction. Now, how they actually get access to you is another question. And it also is a question of, is what's being done criminal or civilly inappropriate? And that gets into more complex issues. But anytime you're offering something that's within the reach of U.S. citizens, it would be prudent to think about U.S. law and its implications. And I know that this is challenging, and I really never want to stifle innovation, but the reality is the regulators in the United States are right now jockeying for jurisdiction, and their ultimate goal really is to protect U.S. citizens. And the frank reality is that very recently here in the States, we had a blow-up associated with one of the people who was considered by our Congress to be a leader in this industry. And as a result of that, we're going to get more heavy-handed regulation because the regulators now feel like they're getting blamed for not having more clear confines around how to act, particularly in the crypto space now. So it's ever more important, and there's one thing that you remember, protect your personal assets. That's first and foremost. I don't want anyone's home or bank accounts or family resources to be jeopardized. And secondarily, please know that the risk is not just with the regulators. If you're acting in the United States, lawyers can and will sue you and come for your assets and the assets of your DAO members if you're not in compliance with law. That's how they're making their living. Not me. I'm friendly. But there are definitely attorneys who make their living that way.
I think just before we wrap up, I'm going to ask a couple of people here. Is there any message that either of you would like to share with everybody here in particular?
Yeah, I'd love to echo a lot of JoAnn's sentiments. Protect yourself, protect yourself, protect yourself. Whether it's in the Marshall Islands, Wyoming, Vermont, Tennessee, or Swiss, Cayman, wherever it is, please protect yourself. If one project fails, at least you get to dust yourself off and build again.
I just want to add something. Everyone knows that the regulations are just around the corner, so it's not only the regulations that are right now, so you have to think about the regulations that are coming to the future. And you have to imagine a future with a regulation that you will never know how they will bring to the world. So you have to think on the future, not only the regulations that are set up right now.
Great. I think there's another question back here.
Yes, the question is for JoAnn. Thank you, lots of information. The question that I have, do you believe that maybe in the future we will have some type of new law for the Web3 or DAOs and anything? Because what we're seeing is the existing traditional law, they try to apply to something that is completely or very different than what the traditional law is for. So do you believe that at some point they're going to have a Web3 law that we can regulate instead of using the traditional law and apply to something that has nothing to do sometime with what we're doing?
So I've been a lawyer for 23 plus years. The first thing I learned first semester of law school is there is no law. There's only interpretation of law. So what one given judge thinks or what one given regulator thinks is going to have a huge impact. So it's not necessarily always an issue of do we need new law, it's a question of how is the person who gets to apply the law thinking about it. I do think there are a number of bills before Congress, and have been over the course of years, a number of bills before the US Congress that impact the Web3 space. But if we think about Web3, it's crypto, DeFi, NFTs, DAOs, and the metaverse, right? And gaming, if you want to throw that in. Those are different things. They're related to one another, but I think that I would rather, as much as I would love to be able to tell my clients with clarity, this is the law, or this is the regulation, and this is how we know it will be applied, I would much rather that regulators take their time and learn that a centralized exchange is not the same as a decentralized exchange. Why is a DAO different than what we're trying to achieve with traditional LLCs or corporations? What's unique about an NFT? What's the part of that that's hashed on the blockchain, and what's the asset that it relates to? So that people are developing law that makes sense rather than developing law quickly that we have to adapt and try to fit into that may not make sense. The other thing is to say is that where there is an opportunity for money, talent and intellect will go there. And so to the point of the panel, the US is not the only place that Web3 is happening. And it may be the case that we can learn from MiCA in the EU, or regulation in the Marshall Islands, or in other parts of the world. I would rather us be careful and deliberate than quick.
So I think that's an awesome question, or the way you frame it, you say, we're trying to take existing laws and shoehorn them into something and it doesn't quite fit. And I have a personal assessment on that. It's not an opinion, it's an assessment. It's data points, I look at them, I make an assessment, which is we haven't yet addressed fundamental underlying questions of law. We've just hopped right in and said, oh, I saw a transaction happen here, therefore I must deal with it with these confines. What do I mean by that? When you think about it, a wallet, your wallet is a secret. Right? Your private key is a secret. It's 12 words. The quick brown fox jumped over, the log. It's a secret only known to you, and it gives utility. What happens when you turn the key? It sends an instruction, right? And it changes the balance of something. There's no universe known to humankind, yet, that has ever considered a 12-word secret property. When I turn the light switch on this wall and I turn the light on, a lot of things happen. I turn the key, it sends an instruction to the network to change the balance of current in the lamp, and then the light comes on. Okay, big deal. But the light is the value. Our law doesn't contemplate that it's the light that's valuable, not the other parts of it, right? And so there's some fundamental underlying legal questions that haven't been answered. In case you're wondering, I believe the tokens are not property. I believe they're valuable. I believe that wallets are very valuable, but they're not property. And the reason for all the confusion and uncertainty is precisely because we haven't answered that question. Now, there's no judge that has proven, tested, or agreed with me. In fact, there's very few lawyers out there that would agree with me. But when you think about it and you say, here we have this new technology, we're trying to apply old guidelines, old rules, and nothing seems to fit quite right. Well, what does that, more likely than not, on the balance of probabilities, one of the presumptions that underlays those guidelines might be incorrect. And it goes straight to, property's been around for 2,000 years. It's settled law. It's not confusing. It's a bundle of rights enforceable on the world in the common law tradition, Roman code. And any way you cut it, it's difficult to suggest those things are property. It's time to wrap up. Thanks for the monologue. I'd like to thank our panelists here.
And I'd like to ask if anybody would like to connect and continue the conversation. I'm on LinkedIn, JoAnn Holmes, and holmes@law.com. Do you guys want to share how folks can connect with you?
Absolutely. So I'm on Twitter at Jalphy x Laurent. I am also at the MyDAO booth if you want to come check us out and see how our legal wrapper can best serve your DAO. And I'm also on LinkedIn at Jonathan St. Louis.
The best way to connect with me is LinkedIn. You have my name in there. It's really, really difficult to me to spell it, so look for me on the conference if you want to talk.
And I'm just Rotorless. You can find me at Rotorless everywhere. And I'm walking around. So everybody, thanks a lot.
Thanks, everyone.
Thank you, everybody.